Welcome to For the Record, an unfiltered view on current trends and timeless advice for surviving in the aesthetics industry. Whether you're an injector, practice owner, sales rep, or marketer, it's time to set the record straight. Each week we cut through the chaos and showcase diverse perspectives and winning ideas from the best minds in the industry. I'm your host, Dr. Tiphany Hall, Chief Growth Officer at Aesthetic Record. Now, let's get started on this week's episode.
Hey guys, welcome back to another episode of For the Record. And today we are on episode 19. Only one more to go this season. It's been an awesome season. And we're going to go back today to Aesthetic Next, to what was one of my most favorite sessions of the whole event. It was all about compliance, legal, how to reduce your risk, reduce your cost, and really think through the day-to-day and where you have exposure in your practices. We talked with Marti, who is the founder and the lead attorney at Marti Law Group, Ben Hernandez, who is a principal and founder at Skytale, Dr. Justin Harper, who is a multiple Medspa chain owner, but also the CEO of Aesthetic Record, and then lastly, Brian King, who is a healthcare lead for Trucordia Insurance, which is a group that's partnered with us here at AR to bring to market a malpractice coverage that specifically features only Medspa. So we reduce the risk of anesthesia, plastics, dermatology, and really focus on just Medspa procedures. So it gets the overall cost down. And we'll go through that product a little bit in detail throughout the panel. But this panel really is about what's happening right now in the market and what's on all of our mind about compliance risk, legal risk, the states changing their rules constantly, medical boards changing their rules, and how to really stay ahead of that. It's also about what to do in case the medical board shows up or the pharmacy board shows up, what to do, what are your rights, and really thinking through what that looks like for you as an owner if your front desk staff knows what to do or your providers, because Justin's gone through several of these and he'll talk through that in the panel as well. But also thinking about your exit strategy. And Ben really covers on the M&A front where risk factors into your overall cost structure and sell structure and what you can get for your med spa as you go to sell it. So thinking about the fact that PE firms don't want risk at all and making sure that you have everything sort of buttoned up, your P's and your Q's, your I's and your T's crossed and dotted so that when you go to market, everything is really, it's compliant. There's no surprises anywhere. So we'll talk through that about your legal risk and how to find a good attorney and what the attorney can do for you to make sure that you have all those things in place. Toward the end, Brian and I will discuss ARAssurance and how you can get a hold of this new policy that really focuses on, again, malpractice just for med spas. So you're factoring out the additional costs you might be paying for derm, plastic, and just other ancillary services. And if you're watching this on YouTube or on Spotify Premium, you'll see at the bottom a QR code. If not, and you're just listening, you can go to Trucordia.com/ARassurance. It's also going to be in your show notes to get an instant quote from Trucordia and see where you fall in line with your policy prices, especially going into Q4, thinking about renewals and what it's going to cost going into January. I know that prices have really gone up, and so this could be an option for you as a practice to reduce some of your overall cost when it comes to malpractice insurance. So a pretty quick discussion about that, but also to give you some really good points about why it's so important to look at your malpractice policy, what you're paying for, what you're covered to do, not do, and making sure that you are notifying your carrier about things that you're doing in your practice, i.e. PDGF, which is right now obviously the hot button on everyone's mind. So, but we'll go through that. It's a great panel, very informative, a lot of really important information here from people who've lived it, and they do it every single day. So I hope that you enjoy it and hope that it helps you think through your own risk in your practice and do even one or two things different going forward. So let's get started. Do you guys want to introduce yourselves and tell us a little bit about you?
Sure. Hi, Ben Hernandez, CEO, Managing Director of Skytale Group. What we do at Skytale, we do two main things within medical aesthetics. One is management consulting, where we typically are helping either founder-owned businesses grow and scale with a strategic scope, or we help financial sponsors like private equity or their private equity-backed organizations with very specific projects. The other side of the house, which is the one I'm primarily involved with, is investment banking, where we typically sell founder-owned businesses to those same private equity groups or their strategics.
All right, so I'm Justin with Marti Law Group, and we have a law firm that specializes in medical aesthetics, work with folks like Ben quite a bit. About half our business is transactional work in aesthetics, so mergers and acquisitions for people who are, selling their practices, selling their med spas, buying as well. All sorts of agreements, delegation, medical direction, all of that. And then the other side is compliance. So, kind of doing an assessment on practices, seeing where they're deficient. We're lawyers, so we keep all the bad stuff we see confidential. and help you fix it so that hopefully at some point you can scale and exit.
Awesome. So I'm Brian King. I'm with Trucordia, and we insure the aesthetic industry. We take care of the malpractice insurance as well as workers' comp. We can cover your property, your employment practice liability, et cetera.
And cybersecurity.
And
Don't forget that,
cybersecurity, thank you
Brian.
very much.
I'm Justin Harper, and in this context, probably most applicable is I started Juvly Aesthetics about 10 years ago, and I grew very quickly, and so I gained a lot of attention early on. So I've been through no less than a dozen medical board investigations in multiple states, pharmacy board investigations, 100% successful with no issues. So I'm very familiar with some of the interesting things that happen in this industry.
So a good collection of people here who kind of work on all sides of the coin. But for you guys in the audience, we have a quick little poll here. Thinking about your own compliance strategy today, how would you rate yourself? So there's work to be done, for sure. I think everyone would say that, right? There's work to be done. We're going to hopefully give you some ideas today about how to get that done. So looking at the poll here, yep, 2/3. All right, well, we're going to get started with Justin's experience, Dr. Harper's experience with Juvly, because as he mentioned, he's been through lots of board reviews and has probably gone through more than anybody I know, and done it successfully. So thinking through that, if there's work to be done, let's go ahead and get some questions for you here. From a provider owner standpoint, you obviously oversee many medical spas, many providers. What are the things that you think are the blind spots in compliance for med spas today?
So I think it depends on your state, and so I don't know how many of you, and I won't ask you to raise your hands because it's kind of anonymous, but how many people have gone through a medical board investigation? I think you see it very differently once you have. So the biggest thing I think people starting are talking to not real experts. So if you go to an attorney who's never defended a true medical board investigation, or they've never actually gone to court and actually had real practical experience. It's kind of like when I look for a business attorney, I want somebody who's actually successfully defended and done litigation. Why I'm looking, so you can pick the wrong experts pretty easily, so I would vet them for a real experience. And I know it sounds simplistic, but most people will take your money if you offer it. So I would just encourage you to do your interviews looking for specific experience that you might need. I can tell you that medical boards lie like it's their job, and I don't think it's malicious. I think it's unintentional. They don't know their own regulation most of the time. I now get calls from them, and they're like, is this legal? And I'm like, I think you should know, but yes, technically it is. And so I don't think they know their own stuff as well as they do. I think we want to be compliant, and so we also let them run through our whole practice because we're afraid when they walk in. And so they may come in with a simple anonymous complaint that's not real, but then they're going to go and try to find something. They don't like leaving empty-handed. So I think you have the right to an attorney. I think that's something that people grossly underestimate or don't have a protocol. And so I would just, you cooperate, but you limit the scope to what's actually the question. And then I think we watch what other people are doing. We're all on Instagram. There's plenty of controversy. We've seen it even at this meeting. And so watching what your neighbors do is a 100% not right. And so if you think you can do it because they can do it, they may just not have gotten caught yet. And so I think you do need to figure out the real answers. And so I just told you something that's technically impossible, right? If I told you have to figure it out, nobody knows it, the medical board lies, and your neighbors are not right, then how do you figure it out? And I think it's a very frustrating process. I had those same frustrations. I'm like, I paid an attorney, I went to the medical board, I'm still getting investigated, like what is going on? And so I think that part of my interest in this area is because I have those frustrations. And I dealt with these in multiple states. And so I think that it's not, if you haven't had one yet, I would congratulate you when you do, because it means you're successful enough for them to care. So not to be the Debbie Downer, but I think we need clarity, and I think a really good expert who can help guide you, somebody who's been through it, is really essential.
And I think the important part is they have a duty to investigate. So even if you've done nothing wrong, if somebody reports you, that's what's happened in your case, they have to come in and they have to come check it out. And I think to your point, they're going to look under the hood to try to find a reason to justify their trip. But in your day-to-day, like what are some things that we should be doing right now to prepare just in case they do walk into practice Monday morning?
So I think we talk about, and actually it's becoming more popular with occlusions, you have your protocol, you know what to do. Do your front desk people know what to do? Do they know who to call? Do they have I have a card, like we're happy to cooperate with you, they know what to say. Here's my attorney, we'll schedule a time to meet with you, right? So I think just stopping the damage is step one. Even if you don't have a plan, you can always say that. Number two, going through the things you know you should be doing and doing them. Get your head out of the sand if you're one of those people. You're not gonna fly under the radar forever. So I would say fix anything you really know, because I would say if most of you really think about it, you're like, I'm probably a little weak in that area. Or you know there's something so for me, one of the things I had to deal with the pharmacy board was in how long after reconstituting neurotoxin can we continue to inject it, right? They had a really strict stance, 24 hours or less. I fought with them, we agreed that's not gonna happen, and they said fine. But if you know that your state's opinion on some of those things that you know you're gonna have to fight out the real answer, just try to button it up and have any kind of evidence-based information. So you can use bacteriostatic saline in neurotoxin. Most people know that that's not on label, right? Sterile saline is the approved thing for all neurotoxins. So if you use bacteriostatic saline, it's a very simple example. You just have a paper that shows that it's standard of care. It's a very quick thing. And then it's hard for me to answer this without being somewhat of a selfless plug in terms of aesthetic record. When I built it, it was so that I could deal with these myself. So when you export a patient chart, it comes with the checklist that the medical board cares about to get them off your back. And so I would just make sure that you're record keeping, pretend like you're going through a patient investigation. So go look up some random patient, pretend they complained about something, pull your record for that, make sure your documentation is proper, make sure you have lot numbers, your traceability. If you have a medical director, probably more so than ever, that they've actually signed the chart, if that's a legal requirement. Don't assume things are getting done, because if your whole team, I can promise you, is 100% perfect on getting consents, questionnaires, and having appropriate supervision, the one person they didn't is gonna be the one the medical board comes in and asks you about.
Agree, and even for pharmaceutical products, damaging things out, when did you dispose of them, they care about all that kind of stuff. But thinking through, once you've done the buttoning up and you're hopefully, you feel good about it, our attorney on the panel here, what's on the pipeline for this year? What are things that are happening that we might not be prepared for just quite yet that you think we should have on our radar?
And feel free to disagree or tell me I'm wrong anywhere.
Yeah, so I think Justin covered a lot of it, which is great. What we're seeing is not necessarily any kind of new cutting edge regulation happening, but it's just a much stronger rollout of enforcement across the board. So, we've had some unfortunate incidents, right? Whether it was an IV hydration, certain spas with kind of breakouts of HIV, some kind of really crazy scenarios. And even if they're kind of a one-off situation, it sparks a rollout across the whole country. As far as, there's just a lot of eyes on our industry. As we've seen, private equity and MSOs and groups are just finding our space, which is super exciting. But there's another side to that as well, which is the regulatory boards are also following suit. So whether it is, the medical board, the nursing board, the pharmacy board, we're now seeing Department of Consumer Protection across the state going after folks for, false claims or misleading advertisements. So if your IV drip, says Fountain of Youth, we've actually had clients now that we've had to defend. Because they're saying, well, you're making a guarantee about the results of your product. That's kind of a new thing that we didn't find 2-3 years ago. So I think it's just so important. I mean, again, Justin hit on so many of these, and some of them may be very obvious, but having really buttoned up procedures. I also often look at the patient journey from the minute that patient walks in the door to their initial exam, their good faith exam, the GFE, to their treatment, to their exit. Every step needs to be properly documented, held in your EMR, proper signatures, all of that, because when there is an investigation, that's absolutely what they're going to come looking for. And unfortunately, what we tell folks is if it's not papered, then it didn't happen. So as much as someone might have been well-intended, if they didn't grab the doc signature or there wasn't a chart, review by the provider, that is the stuff that, of course, they're going to catch. In a former life, I had, like Dr. Harper hit on it, I had a DSO, so a number of dental practices. And don't ask me why I decided becoming a lawyer. It sounded fun, but we exited that, and that led to kind of this life now. But absolutely, once we got big enough, the investigation started happening, from the dental board, from the pharmacy boards. And what we learned is, number one, it's a good thing in a way because, hopefully as long as no one's getting hurt, it shows that there's growth. But it's not really if, it's when, as you scale. So you want to take these steps in advance, have everything papered, do kind of a self-audit. I fully agree with working with attorneys who actually know the space. I'm partial because that's all our firm does. But really working with folks who can kind of just assess your practice, poke holes that you may not see because you're blind to it and you see it every day. As we're seeing peptides and kind of new innovative procedures come out, again, the boards a lot of them don't know. Like Dr. Harper hit it exactly on the head. We'll call them, right, sometimes to get advice, and they're like, well, we can't give legal advice, and you're the board making the rules, so which one of us should go first? And it's a little scary, but what we tell people is like, we're lawyers, so we have to kind of err on the side of caution, make sure the providers are really strict and also familiar with what they're doing, document it, and oversight's so important right now. Medical direction is just really under the radar.
Yeah, I think also OSHA has had a bit of an interest in our industry. I come from pharma, so the claims thing is big for me. If it's like, look, 10 years younger, well, that's not real. Don't say that. That's obviously going to get flagged. Yep. But I also think just in general, in Texas for sure, we've had Jennifer's Law that's come up. We've had cadaver labs get nixed, then come back. Now they're back again. We've had lots of things in our state around who can and can't inject, if we can let MPs and PAs do GFEs or not. There's been legislative session that's been all about medical spas, and I'm sure you've been seeing all of it. It's been a crazy time here in Texas, so I know that we're dealing with it, and it changes every day. If you call the medical board right now, I've done this for this conference, they're like, we don't know. We don't know who can inject. Can't tell you that. I'm like, what do you mean you're the board? But they're like, call someone else. So they don't know, then how should we know, right? It's very, very confusing. But to that same point, looking at just an overall medical spa, what we have, on our table, what are the things like documentation-wise, compliance-wise that you see most often that people think that they have it all done, but then it's like that oh shit moment if maybe I don't have it all done?
Yep.
What's the big gap?
I think the oversight and having that properly documented is often overlooked. There's plenty of, I want to be too critical of services out there. There's plenty of kind of doc-in-a-box services that are out there that, you can get a doc's license and kind of do your thing. We've had folks we've encountered who have said, I meet with my medical director once every couple of years, and I'm like, all right, I don't know if we could even help this client, we want to. But there's such, it's almost scary, there's such a liability there. So making sure you have medical direction, or if it's a state with independent practice, a nurse practitioner, whoever can kind of do clinical oversight, making sure there's actually a relationship there and proper engagement. And again, I'm such a lawyer, but let's document everything and make sure the chart initials are there. And some states will say you need to meet quarterly, right? Or you need to meet monthly. We are very cautious, and we're wanting to meet pretty regularly with your medical director or your clinical director, and making sure you review charts and really stay ahead of that, because every time there's an investigation, the first thing we're seeing is who is overseeing this person, this provider, and where was the breakdown. Yes, your intake forms are super important, your consent forms, all of that stuff, I don't want to minimize it. So the medical direction piece, and also delegation, collaboration, really important. So these agreements that we nerd out on, right? There's a reason for it. We need to really show that the medical director is delegating with proper authority to this particular individual who's injecting or administering a laser. It's within their scope of practice. What oversight protocols are there, what they can do, what they can't do. What happens if the medical director is not available? So these things, obviously, this is why lawyers give you these 20-page documents and you're annoyed, but there is some, why behind it.
That's why they charge so much per hour. Is that what you mean?
I guess so. I mean, we're flat fee, but some of them do.
Well, speaking of money, Ben's our money guy. Ben's always the guy you call when you want to make some money. And I think that we don't associate often enough the risk and the compliance part with what you can actually sell your medical spa for, or what you can attract. And we know that PE firms are risk averse. You always say they don't like risk. They do not like risk. So how does this impact, directly impact the bottom line if I'm going to market with my medical spa?
It's a significant impact, and both Justins have done a good job talking about some of the risks, and fortunately, Justin's been examined and passed, and now he's being asked the questions from the regulatory bodies, which is impressive. But yeah, as Tiphany, as you're saying, private equity does not like risk. And if you think about what that premise is, if I can pull up a couple levels, if you have a company that is cash flowing significantly, for example, the multiple of that is going to go up. And then the question is why? Behind that multiple, inherently what they're saying is a reduction of risk. So theoretically, let's say you're cash flowing $5 million. The reason that the multiple generally gets higher is because the risk is being reduced on that free cash flow. And why is that? You probably have more providers. You probably have a broader revenue base. You probably have a more sophisticated team. You have people dedicated to compliance. You have a pretty good legal team. I completely agree, Justin. You have to have the right teams in place. You're de-risking the business. So that's the concept behind it. So if we go down to any compliance or legal risk, you just have to think about the fact that private equity is not going to take on that risk. They're going to protect themselves. One way is absolutely on value. The other way, though, which is just as important, is deal structure. So they might say this is valued at X. However, we're going to protect ourselves. And within that deal structure, you'll see things like, I don't want to get too technical, but there are holdbacks, indemnification, reps and warranties. And really all that means is there's the value of the company and there's the actual what cash am I releasing to you today. And some of that they'll hold back for a number of years, usually about 2 years, to be able to protect themselves, and they can actually claw that back if any of this compliance and or legal risk actually comes to fruition. So the cleaner the business is, it's going to save you a lot of headaches on the structure side of it, and then it's going to actually allow us with you to negotiate a lot better, because if you don't have that risk, then you're running a very nice, sophisticated organization that the buyer's not going to be thinking, what else is behind that closet that I'm not going to find during this diligence. So it's extremely important for us.
Well, you mentioned diligence. That's always a very cumbersome, long, you make it easier, but a long process. They look under the hood of all the things that you're doing. Every penny you've ever spent, I think it's sort of on display. So when you go through that, what are the red flags you're looking for? What are the things that tell you as the person in between the deal, wait a minute, this could be a stopgap or an issue for us as we go to market with this business?
Yes, good question. So before going to market, what we're doing, as you said, Tiphany, is a buyer is going to ask you for everything you can imagine about your business. They'll probably know it as well or better than you do by the time that you're selling. So there are hundreds of documents that we're uploading. And within that, we also have our own internal scorecard where we're grading our clients as to how a buyer is going to see them for multiple reasons. The two main ones being, number one, anything that you're doing extremely well, we want to be sure that we tell that story. However, anything that we know is a red on our little scorecard, we know we have to have a very good story for it, a good explanation. We're going to be asked about it. And some of these can even be solved prior to going to market. So the red flags specifically that we look for here, I'll give just a few examples. I don't want to put everybody to sleep, but for example, are the providers compliant? We've seen right before going to market expired licenses as an example. That's one that's going to be flagged, uncovered, not a pleasant conversation. Non-practitioners actually owning, if you will, a practice without an MSO, MSA agreement that's correct is also going to get us beat up. We obviously look for any outstanding or pending lawsuits. Certainly any malpractice complaints to the medical board are on there. And these are all things that they're going to protect themselves, the buyers, if they do find something. Doesn't fit perfectly, but I'll speak to it. Like GLP-1s, for example. Right now, there's a lot of discussion. Is it on the shortage list? Is it off? Is it going to come back off or on? And what buyers are doing right now is if your revenue is too high on the GLP-1 side of things, they're actually giving you, and when I say too high, it varies, but think 10%. If it gets too high, they'll either lower the blended multiple, the valuation for the GLP-1 revenues, or some of them don't even count them as revenues because it's a risk. It's a pen stroke risk is what they call it. And it's the same conceptually when we're looking at this, like good faith exams. Justin mentioned if you're in certain states, those are going to get looked at pretty heavily. So those are some of the ones that we look through. And again, some of them can be protected and covered prior to going to market. I'll also add this, a lot of the buyers upon a transaction, they can fix these pretty quickly, but again, it gives them leverage to beat us up a little bit, and they know that competitive tension that we like amongst buyers is not going to be as high.
And when you get caught, that's a bad word, but whenever they find it out, it's like it's too late, you can't fix it. So they have leverage, right? They can say, well, we're going to discount this deal by X amount. So I think you don't want to get in that situation. Fix it before it gets there. But I think part of this conversation today is really around risk, malpractice, and what we can do to kind of help stave some of that off, for you as a practice. So thinking about malpractice in general, specifically, because I do think that's part of all of this, is your risk rolls into that. How many of you think that you've got what you need in place for malpractice? I'd love to kind of hear that, because we had a discussion this morning in Subio's talk about, does your carrier know that you're doing PDGF and you're injecting it, or that you're doing GLP-1s, you're doing all these different things? How often are you talking to them and talking about these things that are happening in the practice? Because if you do have the board come in, there is a lawsuit, it's going to be important that they know. So once a year renewal, okay. There are things we haven't updated or shared. I think it's really important that, be aware of it. Number one is just know what's the risk. So we're going to talk a little bit, Brian and I, about ARAssurance. So we are working together at Aesthetic Record with Trucordia to launch a malpractice product that will help our medical spa industry to hopefully stay compliant and have some good malpractice protection in place. So I'm going to kind of turn it over to you, Brian.
Sure.
Let me see if I can get this to move forward here. There we go. So we've been meeting for many, many months together, going through this and talking through it, because I think what you heard from Dr. Harper, and I agree as well, that this is a huge gap for our industry. And a thing that we should be really focusing on is how we protect our practices and protect your business and your nest egg. So for Medspa specifically, how does this differ than, let's say, malpractice for a hospital, or this rolled up risk?
Sure. So I think the first thing to acknowledge is that the aesthetic and med spa industry is unique. It's ever changing. It's fast growing. It's kind of an avant-garde sort of industry, and the products that are out there, the malpractice policies that are out there right now they're a square box, and they try to figure out a way to fit med spas into them. And so oftentimes you're actually buying into a policy that's really not written for you, and you're buying coverages that you really don't need and don't utilize. And what that means is you're probably paying more than you should be. So what we did with Aesthetic Record, because they're such experts in it and they've got such an incredibly powerful and logic-driven EMR, is put together a insurance program that's specific to the med spa industry and only for Aesthetic Record clients. It contemplates what you do and is flexible so that as the industry grows and changes, we can respond immediately. We don't have to wait for a year or two, as we saw with GLP-1s and exomes, and you couldn't get things done, you couldn't get things covered, you had to go to another insurance carrier. We can respond nearly immediately with just a board decision. So that's why we did what we did.
So we're not doing plastic surgery, we're not doing anesthesia, we're not doing anything that's really invasive. It's looking at that little box to say, what do we actually do in our industry?
That's right.
And I think whether you have a Aesthetic Record or not, going back to your carrier saying, what all are we covering here? Are we looking at risk across plastics? Because I don't do plastics. Or across anesthesiology, whatever these things are.
Right.
Because it does impact the price quite a bit. I think it's a big part of it.
And they'll also put other coverages in there. They'll put cyber and privacy in there. Other carriers, and they'll put they'll bolt on all other kinds of coverages. What ends up happening is you have a claim in one area, and all of a sudden your medical malpractice coverage has been chopped down. And we don't want that. We want to protect you and your license and your patients and your staff should a claim arise. And remember, as we were talking today, you can do everything right. You can do everything right and still incur a claim and be sued. So we want to be there for you as you grow and push your business forward to take care of you.
I'd like to maybe share one thing that's kind of like behind the scenes a little bit, kind of in the rationale and the process of creation, that I think is meaningful. I think they mentioned it, but most of what we pay, for me at Juvly, was going up every single year pretty significantly. And I was curious as to why that was. And it's because we're getting lumped with dermatology and their failure to treat melanomas. We're getting lumped with plastic surgeons and abdominoplasties that go wrong. And so because of the shared pool, we were kind of constantly paying for that. I also think that a lot of people, as you guys all know, there's a lot that comes out brand new in the industry, and some of it is not different at all. It's just a different name. And so I wanted to be able to take a very proactive approach, where if this new thing that comes out you're not going to be covered on is the same thing as something that we already do, then maybe we could just put it in that bucket, and we already know how to handle it. Or this other new thing that nobody's willing to like dive into. I just personally wanted to have, and I have Juvly on this as well now, but I wanted to have a proactive approach to malpractice insurance that was specific to medical spas, because what I've seen in working with regulatory bodies, there is a role, and I think we underestimate the role of a single person in sweeping changes for good or bad. Right? So I've passed legislation in the state of Ohio. I've done enough lobbying and enough of that work to realize that some of the really good things that happen and some of the really bad are because there's a single person who's mad, and they have a friend who's a representative, and they'll sponsor the bill and it goes through. And so having a proactive kind of arm into helping us to not have our rates go through the roof, to be able to make sense of an industry that's going to evolve. Insurance is probably as slow as medicine, or maybe slower.
Yeah, you're right.
There are not many industries that are slower in the whole world, maybe. And so,
sitting right here.
so it's an opportunity, just like with healthcare, right? If you do something new or creative, there's always hospitals are like excited about their 1997 servers. But I think because of that, to be able to take an active approach, a fast approach, all the partners and all the pieces, I'll spare you the boring details, but everything we built for this was to give us a responsive and fast product.
And I think the other part of that, too, to kind of pick up from that is, obviously we're in the industry, this is what we know, we love, we've been in this for a long time, is being able to offer to clients also how to reduce your risk. You know, is it a cadaver lab? Is it coming to things like this? Is it CMEs? Being able to sort of offset some of that, potential risk with
helping your medical director actually know how to manage complications.
Yeah, teaching your medical director what he needs to do or what she needs to do, and some education around it. Because my goal, thinking through this as a person who's talking to many of you every day on the phone or on chat support or wherever it is that we are, you want to know how to get better, how to fix the problem, how to not have a risk or not have an issue, and we want to give you the resources to do that, to say not only hopefully a better product that's a little bit less expensive, but also as an overall practice to be safer and to have like the safety first mindset or the compliance first mindset. You need tools. And I think having a specific knowledge base around what we do in this industry, because it is so different, I think is really helpful. And I think that's kind of the impetus for what we were hoping to go for when we decided to do this. But it is a big risk. I think the amount of products coming to market is so fast, they're so confusing, as we've even seen this weekend, they're very confusing. And you need somebody to help you figure out what to do in your practice and how to reduce the risk. So that's definitely the overall goal. But Brian, thinking about malpractice in general, and even to what Ben said, how do you use something like that tool to help your overall performance of your practice? And financially, long term, what does that look like for you?
Well, for sure. So first of all, with ARAssurance, you're separated from the big pool. So we've got a small pool of homogeneous practices. So that lets us contemplate what's going to happen in our pond, our marketplace. Otherwise, you're in a big pond that have these great big, as you're saying, dermatology, where you have great big claims being dumped into the pond, and as the water rises, so do the cost of your premiums. So you can be doing just fine. In fact, I read the other day that very likely most people in this room are going to go through a 6 to 15% increase on their medical malpractice. Now, maybe you will and maybe you won't, but that's what the industry is saying right now. And it's going to just keep going up, and it's going to keep going up with med spas as well. So for the long term, with something like ARAssurance, you're in a closed pool where you're not going to be getting those kinds of claims from other people really affecting your cost. When we talk about long-term financial performance, again, this stretches out for years, and when it is time to exit and to get involved in M&A, every dollar that you've saved annually goes into that multiplier when it's time to sell your practice, if you're looking to do that. So this is also part of your strategy when it's time to sell, if you're looking to do that.
And hopefully you are. I mean, at some point, right?
Yeah,
you want to retire
absolutely.
and go to the beach and eat bonbons and have martinis.
That's right, the Maldives or something, right?
For sure, the Maldives. So just kind of for the panel overall, just sort of topic of conversation here in the last few minutes, what are the steps that we should be taking, the next, let's say the end of this year into next year, to think about our legal strategy, because that's a big one. Like, people who don't have an attorney make me crazy. Compliance-wise, and also just malpractice. Like, what are, Justin, from your perspective, what do we do like right now? If we don't have you on our docket, how do we get involved?
Yeah, having a great attorney is a good start. Know people if you need a name. I think one thing our practice does is we start with a compliance assessment. We just, let's see where you are today, and there's no judgment, right? But let's see all the gaps that exist. I think starting with that, and understanding what exposure you could have, again, not just from the medical board and the nursing board and pharmacy, but you should be having an eye towards the future, which is where Ben can be so critical to that. So I think just stopping and let's take a look at our practice and see where we're deficient, how we can correct that, and then go through all the fun documentation. Touch base with great malpractice folks to make sure you're prepared for the future. Again, I can't emphasize it enough that as this industry has grown, it's been super exciting to see. But with that comes a lot of the state boards and they're kind of following the dollars to some extent. So I think you really got to be prepared, and really, again, it's not a matter of if, but kind of when you're going to encounter some of these investigations. So just take a look, under the hood a little bit and see where we can start fixing things.
Yeah, I think the years of like buying a bottle of Botox and a few syringes and going around in the back of your car injecting people, those days are done. I mean, 10 years ago, you could probably do that, right? A little like concierge, fly-by-night practice. I think today, you have to have all these things in place, or opening your doors is a significant financial risk. Well, Justin, from your perspective in the med spa, I mean, you're obviously overseeing a lot of people. What do you think is coming?
So this is a pretty morbid view, but so we've always had the luxury of being the next on the regulatory list, right? We're number 2, but we've always had a bigger one, right? So we had the opioid crisis that was the big issue, and then we had the pandemic, which was the big issue. We no longer have the crisis that's keeping the regulatory boards, the other boards, distracted, if you will, and we're successful, right? So as we continue to succeed as an industry, we no longer take the secondary spot, and a lot of people have missed perceptions of what we do. As you know, there's half of the people who hate it and think it's vanity and you shouldn't do it, and it's like bad for some philosophical reason. And so I think we get a little bit of a disproportionate hate, both from regulation as well. And so I think we're in a regulate by reaction. And so because we're pushing faster than they know how to answer, we won't know the problems until they happen. And so I think that positioning ourselves as well-researched, well-organized, that you can defend properly what you're actually doing, gives us a huge opportunity as this comes, it's inevitable, to actually dictate policy, to help them clarify some of their interpretations of their own rules. And I think you could see it from this morbid view, but I think it's also we have an opportunity to make a significant difference, and I think the timing is right now. And then I think the industry is tight. I don't know, everybody I think who speaks is perfect and their practices are growing like crazy, but I'm sure there's somebody out there who's not, or most of us, right? It's a harder economic environment than it's been, and so As a practice owner, I hate wasting money, right? So I think just purely looking at your COGS, going from the top of your list, whatever your biggest expense is, and trying to decrease it. If malpractice insurance is a big item on your list, whether you're part of this and you can use this or not, always try to lower it, assuming you have adequate coverage, right? You want to capture that, and I always say don't just spend the money, but spend it to get an actual real attorney who knows what they're doing to review your stuff, or do something to reinvest that into making yourself better.
What about private equity? Because they've gone away a bit, now they're back. So what are they looking for today?
Yeah, I would say on the regulatory side of things, which has been touched on, things rarely loosen. So I think as eyeballs continue to more increasingly be upon us, Medspa and medical aesthetics in general, and even things like wellness, functional medicine, longevity are flowing under us, I would expect regulatory bodies to be more stringent. So with that, some of what has been said today is make sure that you have a sophisticated team around you across the board on everything you're doing, especially as you grow. So, the right legal team, as has been mentioned, the right, for malpractice protection. And then increasingly so, you mentioned COGS, I would look at everything in the P&L, because one of the beauties about this space is that margins tend to be high. Like I always say, compared to a restaurant where margins are, like 2 to 5%, everyone knows the price of the tomato there. Here, it might be 20 to 25%. So what tends to happen, private equity knows this, is there tends to be a lot of waste that they can then tighten up, keep those cash flows for themselves. So I would look at everything down the P&L, like ARAssurance, for example. I love that you said you founded Aesthetic Record to fix very specific issues. You're doing it again with ARAssurance, and the industry will benefit from that because we won't have all these other outside things affecting it. So I would look at everything and try to tighten that up. And I think private equity in general is looking for, especially with what has been mentioned of more eyeballs being upon us, they're looking just for that more sophisticated business that runs well, that's de-risking, and that is cash flowing nicely. And I think my last point would be, you talked about, Dr. Harper, the additional competition. And what we're seeing here is the market is growing, we're growing, but the number of med spas opening is actually outpacing that growth. So all these businesses, as you continue to make yourself more sophisticated, more effective, that's another reason to do all of these things that we're talking about, is it'll ultimately benefit the business overall.
Yeah, I think there's almost like two lanes. You have regulatory, and then you have malpractice, and they are connected, but they're not the same thing. And I think once you sort of pierce the veil, like let's say it's malpractice and there's a patient claim, you start to pull back the onion layer. It's like, wait, regulations-wise, we're also not buttoned up. I think they really inform each other. And so in a perfect world, your malpractice coverage and your malpractice, group that's taking care of you, Trucordia in this case, helps you to make sure that everything is in place for regulatory, that they really work together, in lockstep, because there is a different set of risks, equally as important, but a little bit different in the two. And so, as you're looking through your books, if you will, just like you look at your P&L, look at all those risks and all those line items and make sure that you have what you need, especially on the charting side, pharmacy side, chart audits. I just think as many of you know, I love compliance. It's like my favorite topic. And I can't talk about it nearly enough, but I just think you've got to be buttoned up. I just think it's a risky place to be.
You brought up a really interesting point that I think is, if you're nerdy enough to do it, is a really great exercise. So all medical board investigations, all pharmacy board investigations are part of the public record in almost every state. So you can actually go and read through most of them. And if there's disciplinary action, if it's so for mine, for example, there are investigations that get opened, there's no action taken, and so they disappear. So you don't see those. But if there is disciplinary action taken, or if there's a complication that played into the disciplinary action, you can actually do those. It actually shaped some of the way we chose certain devices. Certain injectable products have much higher risk than other injectable products, and you can see that on a state-by-state basis, historically, how the medical boards operate. And the point that Tiphany made, and I think it's one that we should directly connect, is why am I talking about medical malpractice? and regulatory compliance at the same time. So in my homework of getting ready to do this, I looked at all large awards in the United States, in this industry specifically, and nearly every single one, almost without exception, was not that you hurt the patient, but you hurt the patient and your license was expired. You did something bad, you doubled down on the bad thing, but you didn't have proper supervision. You were doing something with a product that is not even standard of care. And so for me, it was always, as I started to research this and really try to understand kind of what's actually going on, it wasn't that you had a complication, it wasn't that real things that happened to real people. There was almost always a component for these large awards of, like in the TPN in a clinic code, a non-licensed person, there's always some component of this, are you regulatory compliant or not, that almost made this whole thing go forward outside of the actual what you would normally think of as a medical malpractice case. So I do think that they are extremely closely linked as to the likelihood of it actually becoming a case and the outcome of the case.
Thank you for joining us for lunch, and I hope that you learned a few things and that you're fired up for compliance as much as I am.
All right.
Well, you guys enjoy the rest of your day, and thanks to all of you for sharing
Thank
your
you.
thoughts.
Thank you.
Thanks for having us.
Thanks, guys.
Thanks.
Thanks for listening to another episode of For the Record. This podcast is not intended to provide legal or medical advice. It's for entertainment, education, and information purposes only. For more information on this week's guest or to get started with Aesthetic Record, email us at info@aestheticrecord.com. Be sure to tune in next week for more fresh perspectives on disrupting the status quo and surviving in the aesthetics industry.